see how this goes. Are you seeing anybody on your screen? We're recording now?
Yes.
Okay. Good, then I'm not going to worry about the Pennsylvania wiretap law. Okay. So welcome everybody. Again, given that the King County report just came out last week, I thought I would kind of jump ahead of everybody else and try to get Nina and Mark to come into us and talk about the report, about what was behind the genesis of it, what they hope to get out of it, whether it did, what the process was, and really kind of talk to folks about what they're doing. Because one of the things, see, I told you the light was going to change. One of the things that we have really struggled with, and I know a lot of folks in CIUs all around the country are struggling with, is the amount of transparency. Like, how transparent can you be sharing information? And certainly when it gets into talking about the process for reviewing and potentially working on a case and giving relief, people get very, very nervous about what that process is. So because now he looks very grandfatherly, even though he's not even close to being a grandfather, but Mark has got this very nice, friendly way now about him. I figured he'd be perfect to kind of come in and answer questions or talk about that process for everybody. So I'm not going to talk much, but we will hopefully have plenty of time at the end for folks to be able to ask questions about the process for Mark or for Nina. So by way of quick introduction, Mark Hale is the head of the King County District Attorney, or Brooklyn Conviction Review Unit. He was a career homicide prosecutor, if I'm not mistaken, before being tapped to run the unit by the previous district attorney, and has been in that position since. Nina Morrison is a senior litigation strategy specialist, supernova woman person. Sorry, I bungled your name, your title with the Innocence Project, that she works going around the country and has been really on the forefront of working with conviction integrity units and trying to help conviction integrity units and innocence organizations work together and optimize the reviews for, I just can't do anything about that, optimize reviews for the prosecutors' offices, and really kind of help them just get to where they're going in a way that abides by all best practices. And I'm just going to shut up Nina right now because I'm going to blow it. So I'm going to hand it over to Nina and to Mark. Nina, Mark, I do have a copy of the report up on my screen. If you ever need it, just let me know and I'll pull it up if you want to pull it for reference. So I hand off to the two of you. And thank you so very much for being with us. This is a lot of fun to have you.
Thank you. Nina, you?
Go ahead.
No, after you. I think you had to start.
So, well, Mark and I were joking before this about what most of you know about the unreliability of witness memory, because we were talking about the genesis of the report, and somehow, maybe because it was a challenging project to do, but it turned out really well in the end, each of us seemed to remember that it was our idea. But there you go for subjectivity. You know, I think most of you know I've been at the Innocence Project for 18 years. I've worked with a lot of conviction review and integrity units around the country. I would probably estimate that half of the clients that I've helped free would still be in prison if it were not for someone in a prosecutor's office, usually in a CIU, taking the initiative, finding some evidence we wouldn't otherwise have access to, or otherwise, you know, agreeing to look behind a procedural barrier and restart an investigation. So I am just, first of all, grateful to all of you for the work you do. I can't imagine, although I guess I can because I'm doing it too, how hard it is to do in the COVID era and how much pressure you must be under to get these cases resolved quickly. Also, while you can't go knock on people's doors and get your files even as quickly as you used to slog through them. So thank you for all you're doing in these conditions. And it's really exciting. I know many of the names and faces I see are people who called me a few years ago saying, we're thinking of starting the CRU, and now have several exonerations under you and staffs. And it's really great. So this report, had been something, and we realized, Mark and I, we talked about it, that each of us had been kicking it around separately, and then the idea kind of came together at the right time. So a few years ago, when Mark's current boss, District Attorney Eric Gonzalez, became the elected district attorney, he took over as the acting DA when Ken Thompson passed away. He asked me and many other people from the criminal justice community in New York to be on what was not really a transition committee, but what was called the Justice 2020 kind of policy agenda vision committee, where we would talk about all the vision we had for how the DA's office could do its job better. And so I got tapped to be on a conviction review and ethics subcommittee. It was a very diverse committee, some people who didn't share my views, some who did. But one of the ideas that our subgroup came up with to deal a little bit with this concerns about, you know, transparency and how does the CRU do what it does, how do they pick their cases,
But
as well as
right now, the
oh, somebody's not muted, I think. The positive piece of, you know, my sense was not just as a kind of, they need to explain what they do, but really there's so much, you know, they'd had at that point 23 or 24 exonerations. And when we got to 25, wouldn't that be a great round number to go back and look at all the patterns, what had happened. I was almost envisioning like a 5 or 10 page report that just kind of ran the numbers and had a little preamble. I wasn't realizing what a big project it would turn into. And then it turned out that Mark and his staff had been thinking about this on their own for quite a while. And so we had some buy-in. So I'll let Mark tell you a little bit about the process. We had a big law firm, as you know, Wilmer Hale, that was really essential to helping us get the data evaluated and get it done. But where the report shifted and where, you know, it may or may not be replicable, but because their CRU has, as many of you know, always had a process through which the assistant DA in charge of the case would write a comprehensive memo to Mark, and then that would get submitted to the independent review panel with a recommendation to overturn a conviction. There was a record not just of the investigation, but of the CRU's reasons for why they decided they could no longer stand behind a conviction. And so what was unusual about this report was, unlike, you know, the National Registry of Exonerations, which writes up histories of each case in what's in the public record, we decided that we would base it on the memos of the CRU so we could talk about what was important to a district attorney's office in reaching the conclusion that these convictions were no longer valid. And that's where it was both fascinating, new, and also obviously very sensitive, because we were being given access to the core of their work product. And most of these memos, I would say probably, Mark, like all but the last two, were written by lawyers who had no idea that anybody from the Innocence Project would ever be looking at them, or the public would know about them. And we kept them anonymized, but like they were written at a time when they were written very candidly. So there were also those concerns. So Mark, why don't you talk a little bit more about what our process was?
We, as Nina said, these were kind of parallel thoughts and our ideas. And actually, I do have to give credit back to the Innocence Project, because as far back as when I started in this business in 2014, both Barry Scheck and Peter Neufeld, who Nina's bosses, who you know, basically started the Innocence Project, had been agitating for a kind of root cause analysis of wrongful convictions. That is, the whole where did it go wrong and why did it go wrong sort of thing. And when we were presented with the idea that again came from the district attorney about memorializing when we got to the 25th exoneration, which was, you know, a nice round number and seemed to have some resonance to it, that we would do that sort of thing as a review of the cases that we had done. And I think that again, what makes this difference and what the additions that the Innocence Project added into it was, again, not a thorough root cause analysis, because they were limited by these memorandums that we had talked about, that Nina had talked about. But in terms of just trying to categorize where things went wrong. And this was a significant challenge in terms of the analysis of the cases. And to which the Innocence Project.
Portrait of his cat. There's a portrait of his cat.
That's the report. Yeah, that's what's coming out, report.
No, he has a portrait of his cat.
Are we in business?
Yep, go ahead, Mark.
Okay. Great. I forgot what I was saying. No. You know, so the challenge of this that was supplied by the Innocence Project empirical people and their scientific analysis people was to be able to categorize these various cases. And it was a significant challenge because we often, in the recitation of the memorandums that we had submitted to the court, did not specifically identify and say this fits into this box, because we hadn't really thought of any boxes at that point in time. And then the second challenge was that a lot of these cases ticked off more than one of the boxes. In other words, we had always made our decisions, and the district attorney made his ultimate decisions on, you know, exoneration or not exoneration, on sort of a totality of the circumstances. So it was difficult to do the categorization of the things that might have gone wrong into recognizable sort of boxes, like, you know, police misconduct or prosecutorial error or prosecutorial non-disclosure or you know, witness error or scientific problem or repudiation of a scientific principle or any of those things, false confession analysis, you know, because most of these cases had little pieces of all of those, but very few of them had one overriding thing. So, you know, what we tried to do in terms of the report is not just give the empirical, this is what went wrong, and then try to identify what was wrong, but we tried to give a little bit of the nuance in terms of these investigations, you know, in terms of, it wasn't just a matter of it being accounting sort of thing. So you could say X percentage had this, this had X percentage in these cases, and you know, and categorizing that way. It was to actually give the nuance of you know, how it was that we saw these things, and in that regard, and hopefully that it would be transparent, you know, because, you know, we didn't need to do this sort of analysis for anybody to sit there and say what we had done. But often it was not transparent as to why we had done things, why various facts led to various conclusions. And that was really sort of the essence of what we were trying to get at in the report, was not so much the what, but the why. And to give sort of a roadmap that would tell the people that we're looking at just sort of what our processes were and how our thinking was. I mean, because our standards are out there. We've published those before, but this was a significant challenge because it really was an opening up of how we went about it, so that everybody knew that whatever our decision was on a particular case, it wasn't something that was just, you know, a knee-jerk reaction or a gut feeling, that we really did have hard empirical evidence and some, you know, basis in fact or logic for being able to do what we did. And again, in a lot of regards, that is a reaction to the public sort of perception that this is, you know, leftist progressive mumbo jumbo. You know, they should know that this is something that is a very, very difficult process, and that it, please ignore the telephone in the background. It's based on, again, fact, and it's based on a careful analysis of fact, and the fact that it differentiates what it is that we do in Brooklyn from what was done in the Innocence Project's early days, when you had a very hard and fast sort of, you know, the DNA matches, DNA doesn't match, that's just positive. This is much more, again, I use that word nuance, but it's a lot more subjective in terms of really fact analysis and really looking at, well, what was the role of the prosecutor in getting to where this was and how it could have been done differently? And do you have the confidence in it now that you did then? Should you have had the confidence in it that you did back then? So it's a peek inside of what we do. I'm not saying that all of our answers are correct. I'm not that vain to believe that they are, but it does show you why we overturn these convictions. And that's very important because it shouldn't be easy to overturn what a jury, unbiased, has done in these cases. There should be a good reason for it, and it shouldn't be easy to do it. And we wanted to show people exactly how hard it was that we had to work and what it was that we found to be able to overturn these verdicts and to make a compendium of them. And I think that the main thing about it, the stepping off point comes from the very title, is the 426 years, to illustrate that all of these choices that were made that resulted in these wrong convictions have an enormous human impact, and most especially, of course, for the subject that was convicted, but a lot of other people too. And so that's where the title comes from, and it's appropriate in this particular circumstance.
So I wonder if, Mark and Nina, if you could talk a little bit about the specifics of the process, like how exactly did this work? I mean, you, Mark, have, obviously all the information that you have. How does it go from you to WilmerHale to IP? Who was involved in the analysis, and how did it literally move through in that?
So I'm happy to take a shot at that. So New York law is unusual, I think, compared to a lot of states, in that once the conviction is overturned and the indictment is dismissed and the person's exonerated, the records are automatically sealed by law unless you get a stipulation from the convicted person, wrongly convicted person, except that person and their lawyers will then have access to them. So technically, the DA's office didn't even have access to its own files in the case anymore. A lot of those cases are the subject of civil litigation. We actually didn't even know if we were going to be able to do the project because of that problem. I think in some other states, if you have cases where, say, you filed a detailed either joint motion to vacate or a response to an innocence organization or an attorney's motion to vacate, and that's out there in the public record, there's a hearing, there's a court decision, those records will be there, and they may or may not contain, a lot of the detail that we used. We decided that, in part because some of the Brooklyn exonerations involved just oral presentations that didn't get into the full case history. Some of them didn't involve detailed motions because we were basing them on DNA evidence or getting people out kind of quickly in the early days, with a lot of care and thought behind them, but the court proceedings didn't always reflect the 2 years of investigation that went ahead of it. And we had the benefit of these memos in every single case, which were of varying degrees of detail, and some people would say of quality, depending on who was writing them or what they were talking about in which case, but they were all there. So we actually went, and Mark has a very good relationship with the judge who's presided over most of these exonerations. The general counsel for the DA's office and I went and met with the chief counsel to our state high court's chief judge, who we have a relationship with, explained the project. We were asking for a limited unsealing without the exonerated individual's consent, because some of those people had died, some of the cases were in civil litigation. We just, I love my clients and I love my fellow exoneration attorneys. It would have been a complete nightmare to try to get everybody's consent, and we probably wouldn't have gotten it without a lot of conditions. So we agreed to do it with no names used. So we did these pseudonyms. I mean, almost anybody who Googles the details will be able to figure out which cases we're talking about. So it was a bit of a fiction. But we also didn't use the officers' names. We didn't use the DA's names or the ADA's names, which was somewhat controversial in some quarters. But we decided we really wanted the focus to be on the work and on the case histories and on the reasoning and not on the people involved. So after we got this unsealing order, or probably around the same time, we drafted a memorandum of understanding between our offices and the law firm, in which we had everything from like putting them on a secure server that only certain designated people would have access to destroying the copies, to what would happen if a news organization tried to subpoena them. I think if any of you want to do this, I don't think we would have a problem sharing the contract. It doesn't have any of the details with it. You can ask Mark or somebody in his office, because it's their work product. But the idea was the memos, even though we would write about the memos and the content of them, the memos themselves would still stay protected. And we ran it through a lot of lawyers who know more about this stuff than we do, who seem to think that we were pretty solid. And there had been a news organization that had previously tried to foil the memos, so we knew that, could be an issue. And then, I was a little concerned about how the exonerees and their lawyers would react. I put in a lot of calls the week before to kind of make sure the people who we thought might have an issue understood the importance of the report and the findings. Thankfully, everybody's reaction was really positive. I was pleasantly surprised that people who can be very critical of my office and Mark's were still very thrilled with the end product. And I think that was partly because we really didn't pull any punches. Like, we really did call out a lot of, what went wrong in these cases. And I'll just add a little to what Mark said, that, our hope in the end, by putting in a lot of detail about the cases, would be that people couldn't just be like, well, I never put on false witness testimony. I never take a false confession. I understand eyewitness mis-ID. And by explaining the ways that even inadvertently red flags could be ignored, witnesses, who came forward on day 2 might not have their statements in the hand of the prosecutor who gets the case for trial in year 3, and some, more intentional malfeasance along the way, is the kind of thing that is not limited to Brooklyn. It's not limited to one bad officer, one bad prosecutor, one, defense attorney who doesn't do his or her job, that those are really things that could happen anywhere. And so our hope is that, to the extent any of you ever hire new classes of young prosecutors again, or even senior people, if the budget crisis assuages, it will be the kind of thing people will read as part of their training on what not to do or how to do it better, that it'll be a training tool for CRUs, and also, not that many of your electeds have the time to read 96-page single-spaced documents, but if they're really interested or they need some anti-insomnia cure before bed, it might be the kind of thing that electeds would be interested in reading as a way to think about both conviction review and office policy. And on that note, I will say we printed a ton of hard copies. I know for a lot of people, especially electeds who get a million emails, like having a PDF is not the easiest way to read it. So if any of you would like us to send your boss's hard copy, perhaps with a note from Dia Gonzalez or from us, we'd be happy to do that. We do still have mail up here sporadically, so you can do that. So just shoot me an email or Marissa and let us know.
We have the mail for the time being, depending upon what happens. And going on more of what Nina said in terms of it being instructive, a lot of it is really identifying these problems that come about because we resolve these matters of violation of the criminal law in an adversarial, competitive environment. And what comes along with that is these biases that affect people in the system. And I'm not talking just exclusively prosecutors. I'm talking about cops. It happens with defense attorneys too. It happens with judges. But there are various biases and assumptions that sometimes cloud the better judgment and the objective analysis of these cases. And whereas that might work for people that are in different walks of life in the legal world, it doesn't work for prosecutors because our duty isn't just to a particular client. And so what we have tried to do in this case is to see where, or in the study, is to see where those biases pop up in terms of this adversarial competitive environment. When I talk about a competitive environment, and I think I had said this 2 quadrillion years ago about that it's counterintuitive for prosecutors or litigators in any event to look at these things in a non-competitive fashion. People want to win their case. And sometimes that desire to win, and it's not because they're trying to frame somebody up, they think they're doing the right thing, that they make these errors, that these biases caused by not looking objectively at various elements in the case that should be telling them to go or not go. And I'll make an analogy. I'm old enough to remember, and probably most of you are not, the various space shots back in the late 60s and the early 70s, when there'd be some critical phase of the mission, and they'd be this big room of computer screens down in Houston, and the flight controller would ask all the various people, saying, you know, give me a go or a no go. Well, this is often this process when prosecutors should have been going through those sort of factors on the go or no go, and saying go when they should have been saying stop, or should have been saying, let's look at it a little bit harder. And so it should be instructive in that regard, because listen, none of this means anything unless it changes, or at least reframes the way people, prosecutors, will look at their cases and see where things can and do go wrong, because you know, our entire mission is really public safety, and doing that. And again, this is not a left-leaning liberal thing. This is a practical thing, that you know, these things happen. And a lot of it is also recognition of some of the things that we've referred to in terms of both best practices and expert analysis, particularly in the areas of eyewitness identification and false confession. Now, for years, and I know that I was trained this way, when we learned about false confession and eyewitness scientific empirical analysis, the only reason we learned about it was to try and figure out how to beat it in court, how to upset the apple cart, how to bring it into disrepute rather than scientific veracity. And that may have been the problem, because how it was introduced within the criminal justice system by defense counsel was for it to be proffered during a competitive trial, and for it to be dispositive. And it was never meant to be dispositive, it was meant to be instructive. In other words, so that if you look at it and you credit it, you as a prosecutor should be looking at it in terms of your case and saying, making that go, no-go decision about whether you're going to proffer this particular evidence. And so I hope that the report will frame those sort of analysis into problem areas that we had in cases into something being, again, not dispositive. And in all of our cases that we exonerated, as you see if you read all those single space lines in the report, these things were not dispositive to us. They were instructive in terms of our subjective opinion about the case. And hopefully we will take those sort of expert opinions and those sort of analysis out of that competitive arena and use them instructively in making determinations about the viability of prosecution cases now and in the future.
So if I'm taking the liberty of jumping in a bit. So Mark, I just want to kind of follow up on that, what you were just talking about, this go or no go point. You know, and it's also kind of reflective of what you were talking about earlier in terms of the nuance of reviewing cases from that developing some kind of checklist, definitive objective checklist, you know, for either prosecutors going forward or prosecutors doing post-conviction review, doesn't really seem like something that's quite possible, because each case is so different. There are some nuances. There is different, you know, a confession in one case may have some impact on another, it may have none, you know, in terms of all this. Do you think that this report can be used in some fashion to try to develop some type of objective tool, checklist, go, no go list. I mean, I just saw Hidden Figures, so the go, no go is like really big in my head right now. Like, do you think it's possible to get to that point where there could be some kind of analytical objective tool that comes out of this, either for before prosecutions or in post-conviction review?
It's a little hard to look at things in a completely objective list fashion. You know, but it's easy to see within issues that you have in a case that there are various things that you should tick off. If you have a confession case, if the confession is an element of your case, and I'm even talking about, you know, the era that we're in now of recorded police suspect interactions, that there are things that you could go through which would be a checklist in telling you, do you have a problem? Do you not have a problem? If you have a case that depends upon eyewitness identification, specifically one in which the identification, the out-of-court identification was made later on, you do have a checklist that you could probably work up that talks about how was the out-of-court identification accomplished? Was it in the best practice? That would tell you, should it be a go, should it be a no-go? You know, what was the background of the identification? And again, this is just smart as opposed, and let me just backtrack because, you know, a lot of people have said to me, well, you know, don't these things get weeded out in, you know, in court, in your pretrial hearing? The answer is yes and no, but the pretrial hearings, motions to suppress on statements or on identifications are basically talking about, you know, voluntariness and taint. They touch on admissibility, but they do not touch on accuracy. They do not touch on really truth. And so, you know, that is still left up to the jury. And I think one of the things that is important when you talk about a go, no go or a checklist is that, you know, prosecutors have to be cognizant that you should not be in the position of saying, let the jury decide when you yourself don't have confidence in what has happened here. We should not, as prosecutors, be defaulting to letting the jury decide, because jurors won't always get it right. Jurors won't always get it right, and in the first instance, the prosecutor, actually in the first and last instance, they should be the gatekeeper for charges of a serious nature that are brought against any person. And you know, just defaulting to 12 people that weren't smart enough to get out of jury duty is not a good resolution for how cases should be resolved.
Nina, do you want to jump in on that?
Yeah, I mean, we did, you know, we thought about like whether the report should include policy recommendations, and we decided ultimately we had a big enough job doing what we were doing. Also, that there was a likelihood that the offices may not agree on what the right prescriptive things for each issue necessarily were, and we didn't want to get hung up on that. I will say, for those of you who didn't see it, on the day the report came out, the IP put out our own like 3-pager on here are some takeaways from the report that we think should be considered as a matter of policy. Some of them had to do with eyewitness stuff, some had to do with confessions, like we have a bill pending in New York right now to ban deception in police interrogations, you know, telling a suspect your fingerprints are at the scene, your DNA's at the scene, or this person implicated you when they know that that's not true. Obviously, as you all know, it's perfectly constitutional, but states can decide not to allow it. So I think there's a lot in the report. Like, if any of you have agendas of your own, or your electeds or people that you are working with are seeking reform in particular areas, like, again, there's no reason the stuff in the report is unique to Brooklyn. There's a lot there, like repeat photo identification procedures. You know, somebody's in a photo array, the witness doesn't pick them out, and then they put them in a lineup 3 days later. Guess what? They get chosen because they're recognized from the prior procedure. In-court IDs on their own are nothing but really bad show-ups, right? I mean, under the most suggestive circumstances possible. So there's a lot that I think you could take away from it. And I don't think, I think in terms of your own jurisdictions, like, I don't even know if you need 25 exonerations to do that. Like, I think there are DAs, like our current chief judge, when we had one of the whole state, when she was the DA in Westchester, we had one very high profile exoneration of a 16-year-old who had falsely confessed to a murder, that she was the DA there for the time of the exoneration. And she commissioned an outside review panel, not to review the underlying case because we had solved it with DNA, but to look at what went wrong in the case and kind of do a reckoning and make recommendations. So I feel like if you've had one or two or 10 or 15 big cases, you don't necessarily need to do exactly the kind of report we did to do something that analyzes.
I was thinking about the report, your first one, Shelley, down there, which was an amazingly comprehensive report about everything that had gone on there. Nina's correct. You can do these, again, we were hamstrung by New York State sealing law, but if you don't have that sort of thing, that the one that you did down there, Shelley, that could be a blueprint for everybody to do. And so you would be seeing these trends, and again, there might not be agreement on what they are, but these trends and being able to classify these cases in real time as you actually do the reports and the exonerations, which would save you all the problem of compiling them like we had to do going back into time. And Nina is correct. There are a lot of things that are not unique to Brooklyn, and these aren't. And I think that's why it's basically instructive to everybody that the police procedures do not differ all that much from state to state, jurisdiction to jurisdiction, nor do the criminal procedure laws. And certainly there are universals on constitutional rights that may or may not have been violated. And again, this isn't to say that our courts don't do a good job in terms of appeals and post-conviction motions and habeas corpus petitions. They do. But they can't do it all, and they function on bright line rules, whereas we're in the best position to do something about it because this is all about our discretion and our subjective prosecution in a case, and it's important, and I'm preaching to the choir, I know, but this whole discretionary thing is extremely important in the way we handle cases, and we see it, frankly, every day now in terms of some of the things that have been happening with regard to police misconduct and how those cases are being approached and the discretion that may or may not be applied in those cases. So, this is stuff we can all take home. We can learn lessons through it. Nina didn't learn a lesson with that case she was talking about because that was her case. But, these things come up over and over again. So, take what you will about it. It's not holy writ, but we hope it is something that can help you out and can just give you a little bit of an insight into how we work anyway in Brooklyn, and take it for what it's worth, take it for what utility that you can make of it.
And Mark, just on those lines, Nina kind of shared with us some of her hopes for what the report would do going forward in terms of being used in prosecutors' offices for trainings or for policy development from the Innocence Project's perspective. What did you hope for this report? Like, what impact do you hope it will have, either you individually or on behalf of the office?
Well, I think that, and maybe I was intimating it, but I hope that it won just in general for all offices, that it changes some attitudes in terms of how criminal prosecutions are approached, and understanding, there's a lot of people when they talk about the role of prosecutor and what a criminal prosecution consists of, that thinks it starts from the time that they get their hands on a case and they start putting together the case. If it was an arrest is handed to them, they work on working it through to a trial or a plea, and and the case going the way of all cases and getting a jury verdict. Where I think that we have to expand our idea, because your criminal prosecution actually starts when the actual crime occurs, because that's when things start getting initiated in terms of the witness observations and the police investigations. And you know, police investigation is really the initiation of the prosecution, because all of their inquiries should be, and all of their actions should be with the goal of eventually having a successful criminal prosecution and a guilty verdict somewhere down the road for the right person, the person has committed the crime. And I think what I am hoping that it broadens the perspective of prosecutors as to what exactly is entailed within the four corners of a criminal prosecution, and in terms of their interaction with the investigating agencies specifically, and more specifically, I guess, even is identifying within themselves this potentiality for biases that we have, and we have biases about criminal defendants. We have a biases about crimes. We have a biases about our interactions with the police. We have a lot of things that we have to shove to the side if we're going to get to really an objective analysis of what our cases are. And I think that's probably the linchpin of what I want in terms of training, both for prosecutors going forward, so we don't replicate the sort of errors that we've identified, but again, also for my colleagues and some of the people who have become my dear friends who are on the call here today, who are working in this same sort of environment, so that, you know, we can demonstrate both to the people in our office, the public in general, and the legal community at large, that we're not some outlier in this process, that actually we're you know, all doing the same job that all prosecutors should be doing, which is making determinations about the relative certainty and fairness of what it is that we're doing, so that we can ensure public safety in a just society. I mean, that's my hope that this does. It's a very meager effort in that regard, but if you get some of that out of it, hopefully it's all to the good.
Great. And I have many more questions, but I feel like I'm bogarting your time here, and I want to make sure that we've got about 30 folks who are here. For people who have, you know, questions or comments, or like, how do I do this in my jurisdiction type stuff, please feel free to kind of chime in. Either you can use the chat box, raise your hand, or just go ahead and unmute yourself and just dive right in, because we really want to make sure that we have Mark and Neela here available for everybody to kind of take advantage of their expertise here. So I will pause for a second, see if there's anything coming up in the chat. And just point out that, Mark, you have an adorable dog who keeps like coming in and out of the picture behind you.
I didn't even see which one. That was probably, I have two. I have a corgi and I have a mutt. My corgi is probably the one that you saw, because she's by far the more visually striking. The other one.
That may be.
I saw Shelley with her hand up there.
Okay. Shelley, you want to go ahead?
Yeah, I just have a quick question about not so much the report itself, Mark, but you know, I'm going to be the one that's still going to struggle with the intake 2 years in. I was wondering if when you got the letters from people, if they actually delved into all of the issues. And I was really interested in your analysis about the false confession in particular. And so when people are writing you letters, are they talking to you about, I confessed, but I falsely confessed. I claimed that I stabbed the person, but in fact it was a shooting. I mean, are you getting that kind of detail when you're getting letters from convicted, or are you having to parse this out as you review the cases? Like, you know, how are you getting to these things?
You know, when we screen, Shelley, and I was explaining this to Val a little bit earlier before the bright lights came on. What we look for, and listen, the letters are not that sophisticated in terms of the pro se letters that we get. Sometimes they're more so if we have a case like that comes from Nina or the people from the Innocence Project where they developed it a little bit more. But the things that we have our correspondence with a lot of people is basically to get their foot in the door. They are not so nuanced or so detailed that they will understand about false said statements or you know, confirmation bias or any of those sort of things. In fact, I'm trying to remember the one particular case that you were talking about actually came in from, it was a FOIL request that the defendant had made, which indicated that there was somebody who had been displayed in a show up to the survivor of the robbery homicide. You'll recall that the two guys were robbed, one guy was shot and killed, and in which it indicated that that person had tentatively identified the person that was shown up to him as one of the perpetrators, and it wasn't. And it's funny because when the case came in and we accepted it on that basis, because there had been a non-disclosure that had been made there, you know, and not all non-disclosure cases are cases that are necessarily exoneration, but you know, we had to analyze it to see whether that was a material one. And when the case came in, I remembered the case, and it's because it was something that we had actually teased the assistant about, that, you know, that he had gotten a conviction for a shooting when the guy had confessed to a stabbing. But again, that reminded me there had to be a problem with that. I didn't know all the details of it, but as we got the details of it, we found that there was a very serious question about detective perjury in the case, about how the statement came about, and no, that wasn't raised by the initial question. So to answer your question, we screen these things and they get their foot in the door, but they're not limited to that foot in the door issue. We find other things that come along. And of course, in that particular case, the one that you're talking about, I remembered where that issue was, and we developed it and found out a heck of a lot more about it. And the other thing, the possible non-disclosure had no bearing whatsoever on that guy's exoneration, but the issues that we uncovered in our investigation did. I know that's not much of an answer.
Who else? I am not above using the Socratic method, just to remind everybody that we can call on. One thing I was curious about, Mark or Nina, yeah, I guess this is really more for Mark. Mark, did you find that, I don't want to say find it necessary, but did you have like thoughts about holding back information from this? Like how did you, was it easy to kind of dive in and say, sure, here you go, here are our files? Or was there some hesitancy on the, either your part individually, the DAs, or your colleagues in the office who might have had some questions about whether this was the right way to go?
You mean for the purposes of the original investigation, not for the report?
For the report. But yes,
before we just
information.
used the memos. We only used the memos. We didn't use the underlying documents. So that was
Right.
that was sort of one of the limitations, but also advantages of the report, was that we did not go back to the original case files, in part because they were sealed, in part because the records were spotty, and to do independent reanalyses of 25 cases, like fully, would have taken us years. And so what you see in the report is just data. We had the Innocence Project research team and me as the lawyer sort of knowing what categories to look for, and them as the data people design kind of a database where then with each memo, we had 3 different reviewers go through each memo and categorize like how many years was the person in, like all the demographic data, but then also for each witness, there was a form about certain information about the witness. Was there a confession? If so, a bunch of questions. Was there forensic evidence used? What kind? Did the CRU use any experts? What kind? So it was all, but it was all from a memo that was anywhere from 15 to 80 pages long, that we took the info. And then the report itself weaves in quotes and examples from the memo. And then the WilmerHale folks were really wonderful, and they felt like they wanted to put some of the information into context. So they either did their own research or we sent them background documents on best practices in interrogations or eyewitness IDs so that they could say, you know, the CRU found this ID unreliable for these reasons. And in fact, researchers have documented XYZ with a footnote or something in the text about the practice, so if that makes sense. And I think that there are other, you know, there are other ways to do it. Like if you don't have the memos, but you do have the case files, it would be a bigger job. Like I was talking to one other project about maybe doing an analysis of all the exonerations in a particular jurisdiction, just using the National Registry of Exoneration profiles, which are themselves based on public records and are fairly detailed. You know, just if you wanted to get just an overview of how many cases there have been, how many years people had served in prison, and what some of the common factors were. So I think there's a lot of different ways to do it. We took a labor-intensive one.
Okay, yeah, Mark?
And again, no, just following up on what Nina said, you know, there was the limitation that it was done on the reports, and the reports were, you know, frankly, fairly uneven in terms of the amount of detail that were in them. And plus, you know, early on when we were doing these cases, if we would be charging through an investigation and we'd find what was well, I guess I'll call a fatal error, one that would require vacature, and the guy, yeah, they were all guys with regard to this report. The person was still incarcerated. You know, we felt it was imperative at that point just to stop, identify that one particular error, and get the case gone, get the guy out of prison. Whereas, you know, we could have probably gone on and identified another half dozen things within the case and done a lot more detail. But, you know, we were sort of answering the prime directive was, you know, when you have a person who's incarcerated, to correct that as quickly as possible. And so, you know, some of the memos, you might say, are incomplete in that regard. In other words, they were complete as far as what we needed to do the remedies, but perhaps incomplete in terms of doing a comprehensive analysis of the entire case. But again, that's realizing what the role of these memorandum were, which was not to be a comprehensive record, but they were to be the basis for a recommendation. A recommendation often had to be expedient. So that was the limitation within the report. And as Nina said, you know, we couldn't and frankly didn't want to get into a situation where the people that were doing the report, whether, you know, us in conjunction with the Innocence Project and Wilmer, were really redoing the work that we had already done. So there was no access to the raw materials that were with regard to that. The main objective was to be transparent about, you know, what we had done and why we had done it, insofar as we had recorded it, because what we recorded was what we had done and why we had done it, and not really letting somebody else make that determination for us. It was basically, you know, again, a compendium and a expansion on what was in those memorandums for each of the cases, and a categorization for the things that went on. And it was very critical, the part about that Nina discussed with regard to WilmerHale and what they had done, because often going through these memorandums, we would use phrases that are known within the community, like, you know, the false said fact, or you know, with weapons focus or anything like that. And without the expansion that the and the expositions the people at Wilmer used in these cases, there wouldn't have been as much understanding or transparency to the report, so that, you know, people from all walks, not just within the legal community, not just within the criminal justice community, would know what we were talking about.
And just again, reminding people to feel free to put a question in the chat, raise a hand on the participation screen, or even, oh, there goes Shelley again. Like, awesome. And just Shelley, just give me 1 second. So Mark, just for clarification for people who join a little later, correct me if I'm wrong, the reports that you're talking about that were used to do the report are the reports that your unit generated when reviewing the case that went to the board and then eventually to the district attorney to make a determination on the outcome. Is that correct?
Yeah, there are recommendation memos, and we crank one of those out for every investigation we do, whether we recommend exoneration or we don't recommend exoneration. And so, you know, the one thing that I don't want people to take away from this is the universe of all the cases that are being examined. It's not. It's a universe of all the cases in which we found that there was reasons to vacate the conviction and exonerate the defendant. One of the funny things that has happened was, and it happened within days of this report coming out, was that the office was receiving motions, post-conviction motions, that quoted from our report as if it was, you know, wholly written that this was a reason to find in favor of their particular client. And of course, it's not for that purpose, not for that purpose whatsoever. It's illustrative and it is instructive in some regards. But, you know, again, the great thing about the work that we do, and I'm including all of you folks who are listening in here, my colleagues and friends, that, you know, we do this outside of the judicial system. This is purely a function of what prosecutors should or shouldn't be doing when we undertake to use our discretion to prosecute people for serious crime. And so, you know, that was a funny outcome of this case that has actually been quoted, you know, with page reference and everything in motions that have been made to the court, which I find a little bit amusing. I mean, I think we've done a good job, and I think we're a little bit smart, but not that smart. So it just kind of happened.
Thank you, Shelley. Your turn.
Yeah, I was just going to say that, you know, as I read the report, I was reading it not so much because I thought that I wanted to try to duplicate what you had done with my 2 exonerations. I don't think there's a need to try to analyze what went wrong necessarily, but I was trying to parse out, you know, I'm still trying to get my, you know, hands wrapped around, you know, how does one investigate, you know, these letters that come in, you know, what's the process? What are you guys doing? And Mark, you talked about, you know, totality of the circumstances, because as I'm reading through your report, I'm seeing a lot of, this was interesting, but it would not have supported an exoneration in and of itself. And so I find that a lot, right? I mean, there's not one thing that's going to allow me to recommend exoneration. It's the totality of all of these small things that then amount to something substantial. And so then, you know, I've been struggling with what is the standard. And so I was wondering, does New York have an actual like statutory standard for exoneration? You know, I struggle with, is it clear and convincing? Is it substantial and verifiable? And so, you know, I look at the totality of the circumstances, and then I have to try to figure out, you know, what is the standard? And has the fact that the person might have falsely confessed. Now, of course, stabbing and a gunshot wound is pretty significant, but there were some where you all were talking about, you know, it could have been a minimization. It could have been, you know, this, that, or the other. And so you couldn't rely on it. And so then I struggle with the standard. You know, how high do I need to get to feel comfortable that I'm appropriately recommending exoneration to my elected?
Well, and again, this is what I meant by that we're operating outside the judicial system, because there is a standard in New York on a motion pursuant to our criminal procedure law, by which a defendant can make a motion and have that motion granted to vacate judgment of conviction. We're not bound by that. Again, this is part of our discretion or balance. In other words, the standard becomes when we are looking at the case that we don't have confidence in the conviction, that we, from the totality of the circumstance. In other words, if there was one issue, like you said, that was the sort of issue that according to a statutory or constitutional standard would mandate vacature of the conviction, it would have happened. It would have happened through the appeal. It would have happened through a post-conviction motion. But we're looking at something, that is part and parcel of that, but different in the whole regard. It's that, did we do the right thing that accomplished justice in the case? Do we have confidence that we did everything that was fair, that allowed a just litigation of this particular issue based upon credible legal evidence? That's what we're doing. And again, it's very subjective. And all of your electeds who I assume are the ones that will dictate your particular standards for your particular jurisdiction, there's no right or wrong answer on this, so long as that you are looking at things in an objective fashion. If your elected has said to you, listen, Shelley Thibodeau, I want a conviction review unit, and these are the people that I think, should be exonerated. If they've set that standard, and it will always be a subjective standard. There'll always be a subjective standard. If it was a totally objective standard, there wouldn't be any need for us, because it would be written down in the law, and it would be litigated and decided in court.
Well, let me give a little friendly amendment to that, which is,
Go ahead.
ultimately powerful and wonderful though Mark is and the DA is, a judge did have to sign off on it in every case. We happen
Eventually, yes.
And there is, under New York law, we were lucky that the legal standard, there's no time limit per se to file motions for post-conviction relief. If something wasn't included in your previous motion, but you couldn't have gotten it with reasonable diligence, which the CRU is pretty much always willing to concede, especially if it was something in the state's files or from a state's witness that wasn't disclosed before, or the person didn't have resources and was pro se. There's a pretty generous standard where if there's a reasonable likelihood that the person would not have been convicted had this evidence been known, you can get relief. And of course, there's also a broad category for constitutional violations. And, Mark said, well, if there was something objective, it would have happened. There were certainly cases where the CRU found Brady material in some law enforcement file that wasn't turned over. There were, cases where the science had evolved, that there was a legal hook that probably could have been litigated through the traditional process, but the CRU's recommendation meant that that wasn't necessary. And I know in some states, Texas and others, Virginia, you can't even get an exoneration with a district judge signing off. You have to go up to the high court, so that what you have to show is higher. But, typically I think Mark is right. The standard that we've always urged is sort of, would you prosecute the case today based on all the evidence now? Would you have confidence in telling a jury that you personally in the office believe there is proof beyond a reasonable doubt that is reliable, not just if you happen to credit this witness? And within that, there is, usually a legal way to get there.
I think, again, to add to that, I didn't make it sound like we were omniscient, but there are things within the New York State procedural law or New York State criminal law, which I'll give the legal analysis, which is procedural bullshit, which presents actually in most cases prevents a fair adjudication of factual issues in these cases, and we're more than happy to waive any procedural defects when we get down to the ultimate decision where the court has to sign off on whether our cases should be exonerated or not. And we haven't had anybody complain, so I guess we're okay in that regard.
Don't tempt the fates, please.
No, I'm trying.
I think some of you have probably seen and read, there are places, St. Louis, Philly, where, Tampa had
She's had a tremendous problem down there.
Where there have been some judges that are really threatened by, you know, what conviction review units in particular are doing, and have sort of come in and started appointing different DAs. And I have a conspiracy theory that there might have been like a state AG convention where they all got together and said, what are we going to do about these runaway local new DAs? But that's just me.
Yeah, well,
but it's been a real concern, and I think you know, we're lucky that in many places the judges still think that if a prosecutor comes in and says, I no longer have confidence in the conviction, it's going to take a lot for a judge to say no. But you know, we can't take that for granted.
that is true. And listen, I don't understand the thing that happened down in Philadelphia. I don't understand why judges feel proprietary about these cases. I don't get that, but it again emphasizes that the reason that we have problems that we do within the criminal justice system is because it's administered by human beings that have their own particular problems, biases, and prejudices. And you know, we do what we can to operate within the systems that we've drawn. It may be a little bit easier for us here in New York, and we've had a lot of good fortune with it. But I think that the general feeling around the country and the general support is that people want to do the right thing. And if you present a case where somebody is clearly the victim of an unfair prosecution, or in fact is not the right person, these judges would be pretty hard pressed not to go along with you.
All right, even though I'm sitting in the city of brotherly love here, I will not come to its defense on that particular issue. Having litigated some of those cases, it's beyond frustrating. But we're coming up on our time, and I want to be very respectful of people's times, but we do have a couple more minutes if folks have additional questions or comments they want to throw out to others. I see Sarah's got her hand up. Go right ahead.
Thank you. I have a question, if you have any guidance, Mark, on what's probably a basic, but arguably very important principle about dealing with pro se defendants, and that balance between protecting a defendant's right when you're coming from a prosecutor's office, but yet really trying to delve in and collaborate and research a case, dealing with, you know, a waiver, or, you know, obviously it makes it much more complicated when they're not represented by counsel, and to communicate when they're in custody, and maybe a lack of information. I'm just wondering if you have any guidance based upon your expertise.
Well, again here, when you have a pro se petitioner, since that again, this is outside of the, you know, outside of the judicial system, which means we can't even appoint them counsel. We can't go before a court and have counsel appointed for them. So we try to be as objective as we can with them in very clear language, saying, listen, if you want to do this, you want us to take a look at it, you know, you have to be as open as possible with this. We don't hold it against them if they're not, you know what I mean? If they raise a colorable issue, a lot of times it has very little to do with what their own perception of the issue is, or an issue that we find. So it really, you know, I don't want to minimize the importance of people like Nina and other people who work as private attorneys or in organized innocence type projects. And we love to collaborate with those people by all means. It's one of the things that is all our hallmarks, that, you know, that a joint investigation toward the same sort of goal is better than two parallel adversarial ones. But it often does not require the expertise of counsel in terms of organizing the thoughts in directing or asking that you be able to take a look at their case. We go through a very comprehensive correspondence with our pro se petitioners in trying to draw out exactly what it is that they think that there is a problem with their case, and we give them a lot of the benefit of the doubt in trying to identify whether there's a colorable issue there, that we should take a look at the case. So, you know, that's about the best I could say. I don't like, and I have never liked the whole procedural application checklist sort of thing, which was, I mean, I don't like filling out applications. I can't imagine these guys do. And often they are in language that's very, very difficult for them to comprehend or to really make sense out of. And they don't know what the qualifying questions are one way or the other. And so sometimes they try to tell you what you want to hear or what they think you want to hear. And other times they look at questions like they're trick questions in the application. It's much, much better off to have a dialogue, whether it's through written correspondence or a telephone call or something of that nature. But again, we're very solicitous of our pro se applicants. Doesn't mean that they're right. Doesn't mean they're always going to get a full investigation. But the funny thing is that roughly half of the exonerations that we had came out of pro se applications. That's not part of the study in there, and so that's a pretty high percentage in terms of the cases that came into us either through an audit in which they were not represented at all, or that were petitioner driven and not brought to us by an attorney. So that's the best I can tell you. I think to just, you know, maintain a lot of contact, give them a lot of rope, and try to draw them out in very plain language. It's about the best you can do.
I mean, I think there may be a point where if your investigation is getting to the point where you need to either talk to their trial counsel about strategic issues, about whether certain information was disclosed, about, you know, preserving somebody's rights. You know, if you might be in a situation where you're vacating a conviction, but there's a chance the person could be retried or resentenced. Like, I just, the defense lawyer in me thinks that if there is a moment, and it's like, to use the famous Supreme Court Justice quote, you know it when you see it, where the person probably needs counsel, and it does make your work a little less efficient and easy to have lawyers, but you also have the benefit of maybe being able to reach out to a lawyer that you trust, who buys into the general principle that this is not adversarial, but like, you know, just so the person understands if they're going to sign something waiving privilege with their trial attorney, what the waiver is for, what areas are going to be covered, if there's uncharged conduct, if there's stuff that's outside the statute of limitations, but still might be, you know, something that could malign their reputation or go to their damages. Like I just think it's better to have a lawyer involved at that point. And since they wrote to you, you have the luxury of being able in some ways to help recruit a lawyer that will be constructive and not destructive in that way.
Yeah, except that's a real problem. It's an ethical problem. We're not allowed to refer to specific lawyers. We're not allowed to refer to lawyers. We can't get them assigned a lawyer. It's a very difficult problem.
Right.
It's a very difficult
Some
problem.
places you can, some you can't, I guess. I've gotten some calls. We've found some people lawyers, but it's, yeah.
And it is different from the defense side than it is from the prosecution side on that. You know, most states do have ethical rules that prohibit that kind of activity on the prosecution side, but not on the defense. And Sarah, you are brilliant because you perfectly teed up next month's webinar, which is exactly on that topic. So as
I'm
right
so
now,
glad I could help.
as always, thank you.
Way, like, so we know that people have written to us who might have applications that are on our like 10-year wait list. We can't disclose to the DA's office if somebody's written to us. But if the DA's office has a waiver signed by that person and contacts us and says, has this person written to you? We can then say, yes, they have. We might then be able to get information from the DA's office about the status of the investigation. We could write to, and many of you I know, or most of all of you are in partnership with an innocence organization already on your project. So there's that additional layer of potential communication. Without recruiting us to be lawyers, somebody could alert us to the fact that there's an investigation going on, and we could reach out to John Smith and say, would you like us to take your case on? And then they could hire us independently. So I think there are some ways. And most people who've written to you have probably written to us or written to people in the Innocence Network, is my guess, because they're usually the ones who write to everybody. But no offense, by the time they write to you guys, they're pretty desperate. So or we're just really, really slow. Probably both are true.
Right.
So, I think there are probably some ways.
Mm-hmm. There are, and thank you so much, Nina, for that, because so next month we're bringing Ellen Yarosevsky back, and this is kind of the part 2 of the ethics we had before, where we're going to be talking about working with pro se defendants. And I've had this conversation with a lot of you guys, but it really is, it's very difficult for the prosecutors because you're almost in the position of having to get informed consent from a pro se defendant and do exactly what Nina just suggested, is that you have to inform of what all the issues are. What does confidentiality mean? What does attorney-client confidentiality mean? There's just so many issues that need to be covered really before you can ethically move forward with working with the pro se litigant. But we will cover all of that next month with our webinar. So, and Nina, I'm just maybe inviting you back for that discussion. So hope that this was not too alienating for you.
I'm thinking like somebody should just go to the state bars and get a ethics opinion waiving that rule for CRU purposes. Like that seems crazy that you couldn't get somebody a lawyer.
It's not that it's a rule, it's kind of a gray area, and it's that kind of comes down to that, do you really want to be the one standing in front of the judge, and the judge kind of thinking that you somehow skirted a defendant's rights to get where you were, and that's really, that's kind of the position we're in. So I want to thank everybody for your time, for taking part. We have recorded this, we will have it available for everybody. Same time next month at 2 p.m. Eastern time, and we'll send out the invites. But I thank you to Mark and to Nina for being with us. I'm just so grateful for your time, for the work you did on the report. It's extraordinary. I know it's going to have a great impact, and just so thrilled you could be with us. Thank you. And thanks to everybody else.